beep, beep, beep. Welcome to the Court of the EDI Jester. How the devil are we, peeps? Let's keep going. Whatever happens, you must keep going. March start, warrior teachers, come on, come and join us. New lot are up and started, brilliant. Some great sessions in the last few days, some really in-depth discussions about what's going on. And some people doing some stuff, which is the best bit of all. So do come and join us. I've got a really interesting one for you today. So subscribe, click, do the thing, buy me a coffee, anything you can do to help. To keep things going, I'll be grateful. I've got an article from The Times, which is written by Simon Fanshawe. Now, some of you may or may not know that Simon Fanshawe was one of the founders of Stonewall, has done a tremendous amount of work in the gay rights movement, as a man who should be much lauded for that. Hello, Simon. How are you? Now, Simon and I have got there's an interesting story about Simon and I, which I shall tell you. I'm sure he won't mind me telling you. A few years back, I was somewhat ill. Well, somewhat ill. I was terribly ill, right? And I had to go into hospital for an operation, and I was told, yeah, put everything in order. That's a scary thing. When somebody says to you, put everything in order, this is scary stuff, right? Okay. So I was going into hospital, and I didn't know whether I was going to be coming out again. And at the time, I was running a project for a university based around equality, diversity, and inclusion, which is Simon's field. So I went off scouring the tinterwebs to try and find someone who I could say, look, if the worst comes to the worst, I'm going to put your name on a bit of paper and send my client to you. Okay? Just, tidying up loose ends in case I didn't. Unfortunately for Simon, I did come back. Otherwise, he'd have had the project, right? So I looked at, kept scouring the internet, and I came across this company. I didn't know it was Simon Fanshawe when I rang. And I rang and talked to Simon, and it was only after a few minutes that I realised that it was Simon from Stonewall. And yeah, that was before, not before, but sort of at the very beginning of all this for me. And so Simon was going to, in effect, take over my client if something went wrong. I just thought I'd tell you that because it's an interesting little story. These funny things, these funny coincidences that happen while we're fighting this gargantuan monster that is gender ideology, critical social justice, and all the stuff that comes with it. So I was interested to see that Simon's written an article. Hello, Simon. Simon's written an article in The Times, the most serious of newspapers, one would say the most serious. In The Times, as a result of the win by Rachel Meade, the social worker that I covered the other day, who took Westminster City Council and Social Work England to the bloody cleaners, right? Well, we're hoping she will. Hundreds of thousands. That's what I want to see. Hundreds of thousands. I know it's public money, right? But the public need to be angry about this. And the easiest way to do that is to tell them we've just paid out $1 million in public money because Social Work England and Westminster City Council are mental, right? That would be a good thing. We could put that in the paper, right? So Simon's written about this, and he said in his heading, "Beware the culture wars, how employers can trip over trans issues." Tribunal rules in favour of social worker Rachel Meade, who posted feminist views about gender debate on her private Facebook page. "Employers beware," Simon begins. "An employment tribunal ruling was handed down this week which makes it clear that taking sides in the so-called culture wars will end up with you in court and paying a hefty bill. Under UK law, your staff have the right to both hold and express beliefs which, as the judgment said, whilst they may well be profoundly offensive and even distressing to others, they are the beliefs that are and must be tolerated in a pluralist society. This is in particular the case where a belief or a major tenet of it appears to be in accordance with the law of the land. Well, of course, you might think, who would not agree with that major tenet of democracy and free speech? In this case, Westminster Council and Social Work England, the regulator for social workers, although both of these organisations operate in the public sector, this judgment against them and in favour of an appallingly treated employee is a warning to all employers, public or private, that staff are entitled not only to hold views, but also to express them." That's the important bit. "And they cannot be shut down or disciplined simply because other colleagues find them disagreeable. If you say you value diversity in your company, that means diversity of views too." For more than 20 years, Rachel Meade has been a social worker in Westminster. On her Facebook page, which was set to private, she posted messages to about 40 friends. These included links to petitions to the International Olympic Committee that male athletes should not compete in female sports, an argument that women should have the right to maintain female-only spaces, and one that wanted policy change so that male prisoners were not remanded to women's prisons. In 2020, a fellow social worker and Facebook friend, a trans man called Aidan Walton, now working for Sport England as a strategic lead on equality, made an accusation to the regulator that these posts were transphobic. Horrible woman. Because of this single complaint, Social Work England initiated a fitness to practice investigation into Meade on the basis of the regulator's action. Her employee suspended her. Meade responded by suing for unlawful discrimination and harassment. One crucial lesson for employers from this case is that neither the regulator nor her employer did anything to investigate the motivation of the person who complained. They accepted at face value the accusation of one colleague. Very interesting that Simon points that out. This is the setting up of the priestly class, of another class of individual who is separate, almost in a kind of ordained way, can make pronouncements about others and be believed. That's what this is. At the judgment, damningly declared, this was indicative of a lack of rigour in investigation and an apparent willingness to accept a complaint from one side of the gender self-identification, gender critical debate, without appropriate objective balance of the potential validity of different views in what is a highly polarised debate. Now that's a quote from the judgment there. I've got a problem with that, but then I would have. It's me, innit? For a start, so that'll tell you. I've got a problem with that. There aren't two sides, there's only one side, right and wrong. That's it. I mean, there's only one side that's right, and that's the one about reality. The other one is, it's not two sides implies that there can be negotiation. There can't. There can only be eradication of the idea, eradication of the tenets of these people, and that they must be pushed back against wholly and removed from our society. This matter in the current atmosphere, especially at work, says Simon, it wasn't just sloppiness on the part of Social Work England. It is a part of a trend that simply to point the finger is seemingly enough to tarnish someone who holds a different view as offensive or discriminatory. Disagreement has been turned by activists into a moral question rather than an intellectual or political one. My view is good, yours is evil. It was enough that one person made an accusation for the regulator to warn Meade that her fitness to practice could be impaired by virtue of being conduct of a morally culpable or other disgraceful kind. In effect, the accusation itself was enough to define her offence, find her guilty, and mete out the punishment. That some people find a belief offensive is not enough in law to make it so. The test must be objective. As the tribunal commented, given the vitriolic nature of the debate, the fact that offence is taken is not the same as a remark being objectively considered to be offensive. Remember, says I, you choose to take offence. Offence is taken, is not given. So when somebody says, well, I think that's offensive, my general answer is, so what? So what? I don't care. I'm offended by that. Good. What do you want to do? What? What's up? You want a fanfare? No, right, okay. Just because you're offended doesn't mean anything. Don't care. When people do that, because they do it, you get people to sit around the table, you get some snowflakey twat, right? And you sat around the table and they'll go, I'm offended. And I'll look at them and go, right. And then look at everybody else and just carry on talking as if they're not there. That's what you do. Right? Use a bit of peer pressure. If you're going to be snowflakey about this, just leave, because the rest of us aren't going to have time for that. They never do. They sit down then and shut up and start talking properly. That's how you deal with them. Shame! Social shame, these swine who are offended at every fart and every belch. They drive me mad. There are limits of freedom of expression, says Simon, in public and at work, which the tribunal examined. But the issue is not the expression of the belief. It is the manner and tone of that expression. Any discriminatory effect or finding of harassment is dependent on the evidence in a specific context, and any limitation on freedom of expression has to be justified and proportionate. Employers cannot simply take the view that some beliefs are inherently discriminatory, or in this case, transphobic, and so sanction a member of staff. This ruling reinforces the current law, which too often is not properly upheld by diversity and HR professionals. It is worth employers taking serious note of the last paragraph of the judgment. The options expressed by the claimant could not sensibly be viewed as transphobic when properly considered in their full context from an objective perspective, but rather her expressing an opinion contrary to the interpretation of legislation, or perhaps more accurately, the amendment to existing legislation advocated for by trans lobby groups to include, but not limited to, Stonewall. A great piece there from Simon. Simon's book, The Power of Difference, is now available, and Amazon, etc., etc. You can get it from there and listen to what Simon's got to say. Simon does fantastic work, and he was brilliant at Stonewall. But we are not on the same page, Simon and I, which is fine. Right, that's the whole point. Simon can say something, and I can go, "Yep, I think that's great," or actually, no, I've got a problem with that. Whereas I would go, "Yeah, no," and Simon will go, "Oh, no, he's wrong about that. He's wrong about that." Why can't people do that anymore? Why can't people do that anymore? But that's where we are, isn't it? Offence. I've taken offence. Damn, I'll never keep the dog in the yard now. Go away. See you later.